Bonjour, my name is Fabienne Atkin. I'm a solicitor at Heslop Platt. My presentation will focus on the main points and issues that we come across at work, and hopefully I will be able to give you some tips as to avoid them. First of all, Heslop Platt, who are we? Well, we are a law firm based in the UK, in Leeds. We are regulated by the SRA and fully insured, which means that you are safe with us. We specialize in French law and only in French law, with a particular emphasis on French conveyancing, inheritance and succession. And that's all we do. We are a very small team of solicitors and legal assistants. We are all bilingual. We all studied French law as part of our study degree. So language will not be an issue with us. So the French legal system, as Gail mentioned, it is indeed safe, but there are pitfalls. And what is really important to understand is that it is different from the conveyancing process in England and Wales, in that you commit yourself to the purchase at a very early stage, and at this stage you might not have necessarily received any independent legal advice, and especially independent legal advice in your own language. The contract you will be asked to sign is technical, and putting it through Google Translate is not going to help. You will also be provided with pages of ancillary documentation, which has got a lot of small print and is all in French. You need to understand. You need to realize that the contract is negotiable and you do not have to sign what is presented to you. However, it is really important that you fully understand what you sign and realize that you can ask for clauses to be inserted for your own protection. There are, of course, very good estate agents like Beau Village, who will explain the paperwork to you and help you alongside your French purchase. However, not all estate agents are as professional as them. And also, a French notaire is involved in the process, but might not necessarily be involved at the contract stage. And even if the French notaire speaks English, you will not receive the same level of client care and services that you would expect to receive from an English solicitor. And this is where we can help. So first of all, let's talk about finance. So if you say in the offer that you are cash buyers, it means that you have got the cash available now in your bank account. It does not mean that you will be cash buyers once you have sold your UK property or received an inheritance that is due. This is very important because we often come across buyers who are financing the French purchase from the sale of the proceeds of their UK property. And we see at work it can cause a lot of stress, as you can lose the property if the UK sale falls through at the last minute. You can ask for a condition in the contract which makes the French purchase conditional on you selling UK property, but not all the sellers will agree to it, or they might agree under certain conditions and or time scales, and again it can make the whole process very stressful. If you are looking to buy a second home, using a French mortgage, loan interests are quite good at the moment in France, so that's definitely an option that you could consider. And the contract must be conditional on you receiving a loan offer within certain time scales. If you do not receive this offer that matches the criteria on the contract and within that set time scale, you will be able to walk away from the purchase and recover your deposit. However, this protection will not be available if you are financing the French purchase by remortgaging your UK property. So you will need to bear this in mind and ask for a specific condition to be inserted in the contract. And of course, for the transfer of your funds, think about using SMART, your currency broker. Now, in terms of surveys, sellers are required to provide you with a set of reports called diagnostic surveys, and you should receive them at the time or before, in fact, you sign the initial contract. The surveys will comment on various aspects such as asbestos, lead, oil, electrical installation, and so on. They will highlight various anomalies, some of which can be quite costly to remedy. For instance, you may find out that the septic tank is not compliant, and you as future owners will be required to put it right within 12 months of buying the property. So this can add to an outlay of up to 8,000, 12,000 euros, and which is the reason why it is always a very good idea to have the diagnostic surveys as soon as possible. And if they are already available, ask them before you even make your offer, so that you can tailor that in your offer and any hidden costs. On another point, the diagnostic reports are not going to comment on the structural soundness of the property, and it means that you should consider obtaining your own independent survey. Don't discard it. You are entitled to obtain one, and you can make your offer conditional on a satisfactory survey being obtained. Again, my advice is that you obtain your survey as soon as possible, and by all means, before you are bound by the contract. Okay. Now, turning to planning. This is a very big issue, and we come across a lot of files where there has been a planning breach. So when you view the property, please ask and be nosy. You need to check if the property has been altered in any way. Has a barn been converted? Was an extension added? Was a swimming pool constructed? Because any works which change the use of the property or its external appearance will require some form of planning authorization. And if there is a breach of the planning rules, various sanctions might be imposed on you. And that's the case even if the works were undertaken more than 10 years ago. For instance, if the property is damaged by or destroyed by a natural disaster, you may not be able to rebuild it as it was, or also, if you are planning works which require some form of planning authorization, your planning application might not be granted because of the previous planning breach, or you might be asked to remedy it before you can go ahead with your own works. So that's very important to ask questions and insist on a response as well, even if the works are more than 10 years old. So equally, if you intend to undertake some major works, you need to check that your project is feasible in accordance with the general and local planning rules. If the property is situated in a protected area, there will be stricter rules, and your application might take longer as well, as you might have to involve the Architecte des Bâtiments de France, which adds a delay of approximately 1 month to the application. If your project is very important to you and to your enjoyment of the property, you should negotiate a condition in a contract that you obtain full planning permission, or at least an outline planning permission, which will give you an indication as to whether or not your project is feasible. The outline planning permission usually takes 2 months and runs alongside all the inquiries and purge of the preemption rights that the notary will undertake following the signature of the contract. I'm saying that because at work we often come across sellers or estate agents or even notaires who tell us, oh no, the sellers won't accept that because it takes too long. But in fact, if you start your application at the very early stage, you'll probably have a response by the time the file is ready for completion. Now I'm going to brush on taxes. So there are various taxes that will apply in relation to your future property. On a purchase, the notary fees will be payable by you, and they will include the equivalent of stamp duty. So you should budget, as Gail mentioned, approximately 7.5 to 8.5% of the purchase price. As property owners, you will be required to pay the equivalent of the council tax. And in France, it comprises two taxes, which is the taxe foncière, local land tax, and the taxe d'habitation, the occupier's tax, who is payable by whoever occupies the property on the 1st of January. I just would like to mention that if you are planning to rent the property on a seasonal basis, you as owners will still be required to pay this taxe d'habitation. Of course, if the property is let on a long-term basis, that will be the tenant who pays that. You might have heard, but President Macron has also introduced some exemptions that will be gradually implemented. I would like to touch on wealth tax as well, because it has been reformed as well by President Macron. And since the 1st of January 2018, it only applies to the net value of an individual real estate, but it includes property rights or shares of property held in trust of a company like a SCI. If you are a French resident, all your worldwide real estate will be taken into account after 5 years of residency in France. If you are not French resident, only the French real estate will be taken into account. However, no declaration will be required if the net taxable assets are worth less than 1.3 million euros. So obviously that may not apply to you, but I just wanted to mention it. Again, something that is worth mentioning is capital gains tax on the resale. So if you are, when you come to sell your property, if you make a gain, you should know that you will be liable to pay capital gains tax in France, and the applicable current rate is 37.5%. You will benefit from taper relief from the 6 years of ownership, and will also be able to deduct some costs in respect of works that you have undertaken at the property. And this is what I would like to mention, because if you are planning to do some works at your property, you should be aware that only those works that are improvement works, as opposed to maintenance works, will be deductible. And you also need to instruct contractors that are registered in France. Otherwise, those works will not be deductible when you come to pay capital gains tax on the resale.
Sorry, Fabienne, can we?
Yes, yes. I don't have much longer. I'm going to touch on estate planning and inheritance tax, because I know that it is a big issue for a lot of our clients. And we also advise you on this as part of your purchase. So we advise you as to how you should structure the purchase in the most appropriate way to you. So whether it is the most tax efficient, or whether you would like to safeguard the interests of the surviving spouse. Wherever possible, we always try to find a French solution that is tailored to your needs, because it tends to facilitate the succession and probate formalities in France on your death. However, you will be aware that it is sometimes not possible to bypass the French rules of reserved heirship that entitles children to claim a share of the deceased estate. And if that's the case, you might have heard that you are able to use the EU succession regulation that allows you to make an election of the law of your nationality, that is English law, to apply to your succession as a whole. I just wanted to mention that if you do use this option to elect English law, our advice is that you make an English will that is specific to the French assets, and that will go alongside your traditional English will for the rest of your assets. That's because the trust provision and executor provisions in France can have disastrous tax consequences. So that's the reason why our advice is that you make 2 wills. And also note that French inheritance tax will still be applicable even if you make an election of English law. So to conclude, if you should leave today with one conclusion, is that you really need to understand what you are signing, and you need to understand what you are signing, obviously, before you commit yourself, which is quite early on in France. So this is a major investment, and I know that for some of you it is actually a life-changing decision as you are planning to move to France. So it is essential that you come prepared and take professional advice. And trust me, it is a false economy to try and do it alone. So thank you for your time. Merci.